permits for a warehouse, which prohibits you from keeping outdoor storage. He and his attorney had said that they were fearful that they were going to have the product stolen that is keeping outside is a violation of the law. Mr. Freeman and his attorney has gone his own claim, and they have not abided by any rules and regulations set by city of Dallas as was instructed.
Mr. Hawkins, so you're saying that they've violated the city rules and regulations? Is that what you're saying?
He's never pulled a, yes, sir. He's never pulled a permit. He's never gotten consent. He's told to come out of the line.
Has the, okay, so, all right, go ahead.
And if you see, when he found his deed with the court, he knowingly and intentionally did not file the special warrant deed that's attached to it. And that he signed off and agreed that he would not erect one on that property. And that if he did, he would go through the adjacent property that's up front of his building that he has an agreement with.
All right, thank you, Mr. Hawkins. Mr. Leake, why don't you call your first witness?
Okay, Your Honor, I would call William Freeman.
All right, Mr. Freeman, is this the gentleman with you?
Yes.
Please raise your right hand. Do you swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth? I couldn't hear you. Say that again.
I do.
Okay, go ahead.
State your full name. William D. Freeman. And who are you married to? Mary M. Freeman. And what is your occupation? General manager of Omni Marble Company, Incorporated. And how long have you been in that occupation? Since 1985. And where is your business located? On 2407 Al Lipscomb Way, Dallas. And is next your property a business that is owned by Mr. Charlie Freeman, Hawkins? Yes. And prior to July of 2021, had Mr. Hawkins ever come to you and showed you anything to say that your building encroached on his property? Yes. Okay. But in July of 2021, did he come to your building and make that accusation? Yes. And what, if anything, did he have to show that you were over on his property? He had a map that was called a shadow graph that was a planning map from the city of Dallas, and it had no dimensions or any survey information at all on it. It was just a planning map. I took it down to the city and asked them, and they said that that had nothing to do with the property lines or anything like that. Okay, so did you then obtain a survey yourself? I did. And who is that prepared by? Garcia Land Data Company. All right, Your Honor, I have 9 exhibits, and they've been sent to the court reporter, I believe, and also sent to Mr. Hawkins.
I've only seen exhibit numbers, and maybe I didn't get both emails. Oh, never mind. They're out of order. It looks like is there a 1A,
Yes, sir.
2, 3, 4. Yeah, they're all out of order, but okay, they look like they're all here. All right. Are you offering 1A and 1 through 9 as exhibits?
I am.
All right. Any objection by the defendant? Mr. Hawkins, any objections to those exhibits?
Yes, to the authenticity of the survey. The surveyor was supposed to be done by Garcia Incorporated.
Which exhibit number is that?
I'm sorry?
Which exhibit number is the survey? Mr. Leake, what exhibit number is
this? Exhibit 1.
So you don't object to any of the other exhibits?
I object to that exhibit due to the authenticity of it. The company is not licensed as a survey and does not have the right to issue a survey.
So
Therefore,
Mr. Hawkins, my question is 2 through 9, the other exhibits in 1A, do you object to any of those?
I don't have those in front of me and I can't see them.
Did you send those to Mr. Leak?
My assistant did, Your Honor, about 10 minutes ago when I sent them to the court reporter.
Is that the first time you sent it to him?
Yes.
All right. Why don't we do this? Mr. Hawkins, your connection is really bad. It's very hard to hear you. We're going to reconvene this trial at 1:15 to give you guys, Rhonda, what time is our meeting with Felicia Petrie?
12.
What, 12 today?
Yes.
Oh,
She just said the afternoon. She didn't say exactly what time. She just said the afternoon.
okay. So we don't have a time. All right. We'll need to contact her and find that out. So you guys sign back onto Zoom at 1:15. Mr. Hawkins, you need to find a better connection, some other way to do this because we can't hear you very well. So you need to get a better connection. And during that time, Mr. Hawkins and Mr. Leak, I'm going to put you into a breakout room so you guys can talk about the exhibits and see what you can agree to. All right. So I'm putting you into a breakout room right now, and we'll see you back at 1:15.
Thank you, Your Honor.
Mr. Freeman, Ms. Lee? Hello?
Yes, I can hear you. I'm going to see if I can connect you to Mr. Leaks. Mr. Leaks, can you give me a number and I can go ahead and transfer the call to you so you can talk to Mr. Hawkins? Oh, he's already off. Let me see if I can find a number.
Hello?
Yes. Let me send Mr. Leaks your number and he's going to give you a call, okay?
Okay, thank you.
Okay, bye-bye.
And Rhonda, I'll put you into the breakout room so you can chat with them.
Okay.
Oh, that may be the verdict.
This is David. All right, appreciate it. Thank you.
We've got a verdict. All right, Sonia, what do you think? You got this? Oh, Melissa, you guys can you text Melissa and Sarah that they can come back at 1:15?
No one, Sarah?
What did he say?
You guys can come back at 1:15.
Okay. Sarah's asleep. I'm gonna go turn her laptop off.
Okay.
There's an ocean. Get out there. It's not gonna be.
All right, I will call with the verdict, unfortunately. Verdict. So question number one is a no for everybody. So question. In the future, when you submit a charge, you should not actually it should not have this uncertified. So that should be an action there. If they said we included all the questions, those questions would go one. I guess that's the only one they actually answer. But so what we want to do, send it back with deliberations unless you guys want to just agree with.
Oh, it's the.
What they're saying is they agree with question number one. Which is the only one they actually answered. They really should have said all, but this shouldn't even fit in here. But it's up to y'all. Tentatively, it doesn't matter.
Well, can we discuss how we're going to do that, Judge?
I know how to do this. I'm doing this. Oh, God. All right, let's bring the jury in.
Yeah, there was no negligence to pay for his damages.
You want to break that news to me?
What's that?
You want to break that news to me?
He emailed me last night about 10 o'clock. I'm surprised my colleagues don't check me out that late, but it said, how was the status of the trial? I said, man, it's a long story. We'll be done tomorrow. I'll let you know. Can I buy you lunch next week?
Go ahead. Next time.
We don't pay much attention somewhere. Because we very rarely. When we do, I mean, yeah, typically these people, but they feel it's not conducive. We're from here.
All right. Okay, everyone can be seated and the presiding juror please stand. All right. Court is going to read the verdict. Question number one, negligence and those names below possibly cause the first question. A, Goodell, no, Sailors, no. B, Allure, Alou, Malin, no.
C, Amin Al-Mahdi Al-Hazan, no. D, Amanda Violas, no. E, An Toyet Mai, no. Question 2 is not answered. Question 3 was not answered. Question 4 was not answered. Question 5 was not answered. Unfortunately, there's a problem with the verdict certificate, and it's just because it's the way it's worded is a little confusing. You've answered at the bottom. 10 people agree to the verdict. That's right. There's 10 that signed here. Agree to the following questions. To indicate if in order for us to have a verdict, they have to agree to the answer to every question. I understand you didn't answer the other questions, which is fine, but they still have to indicate they agree to that. Does that make sense?
And also, one other question I would ask you was, it shows it could be signed at the time,
If it's a unanimous verdict,
meaning all jurors,
agree,
not just 10.
not just 10, right? If it's unanimous, then the presiding juror would sign at the top. If it's not unanimous, then the jurors would agree to the verdict. But the problem with it is it says they only agree to question 1, they have to agree to every question.
So we can add the words and all question.
The number?
Or do we need to have a number, either all, if they all agree, it would need to be, either the numbers or all questions or something like that. If you all agree to that, I assume that you do, but you need to go back and.
They have agreed to that.
I have to send it back. Okay. It might take 3 seconds to do it, but I have to send it back.
All rise.
Sure.
Go ahead. So we're agreed on that right here, 1 and all.
That's what I think too. You want to get a picture?
I found mine.
Oh, good, okay.
I want to get a copy of the final.
Objections by instructions to the jury.
No, Your Honor.
Not from, no, Your Honor, no objections.
What law firm were you all with?
Where?
Welcome to Dallas.
You know, you used to have an office here?
Yes. Are you all from Houston?
Oh, I'm sorry.
Tell this jury does not like each other already. That's right.
It's 2 days ago.
Yes, sir. All right. Ready? All right.
Yeah, I'll fill it out. I'll get you that. Go ahead.
Please be seated. All right, let's try this again. Question number one, the answer to the negligence of any of the things below possibly causing the person in question. Answer to all 5 subsections was no. And then question 2 was still not answered. Question 3 was still not answered. Question 4 was still not answered. Question 5 was still not answered. The court will note that the jury has indicated that at least 10 jurors agree to questions 1, 2, 3, 4, and 5. And is that correct? That is correct. All right, is the request to poll the jury from the plaintiffs?
More clarification.
You have a request to poll, would you like me to poll the jury?
No, Your Honor.
The request to
No, Your
poll the jury.
No, Your Honor.
All right, you may be seated. The court is going to accept your verdict. So up until this time, you've been told you can't talk about this case. Now you can talk to whoever you like. The attorneys may have questions for you at some point that you can meet them over by the elevators if you'd like. I want to thank you so much for your service. I know this case went a little longer than we expected, but we appreciate your service. I know it's been a long day and a long week, so we're going to go ahead and let you go. So if you guys want to head out right over here, we really appreciate your service, okay? You guys have a great day. Court is dismissed.
All
Thank you.
right.
I don't know that, maybe this is Johnny Depp problem. Thank you so much for your service. You can Gary. Yeah, the badge is go to Gary, sorry. All right, I'm instructing Mr. Garner to prepare judgment in accordance with the verdict. We have 30 days, we'll put this on a 30-day VWAP. You guys try to start the case this week, we got it done, and you guys have a great rest of your week, okay?
Thank you, Your Honor.
We have Luke, Drake, and Paige, well, Matt.
Your Honor, can I say one more thing? First of all, thank you for your time this week. Second, I have a case with ex-judge Carlos Cortez right now. And I'm going to hold up the case, and Steve mentioned your clock and how awesome your clock is. So I just wanted to, I haven't seen it, but I'm going to take it as notice.
Tell him I said
I will.
I don't usually try to talk to jurors.
I'm sure they're not going to be able to.
Thank you. Nice to meet you. Thank you.
Thank you. Nice to meet you. Thank you, sir. Nice to meet you. Thank you. Appreciate you.
Thank you.
All right, on to the next one.
On to the next.
Got everything?
I'm sorry? They just went down this, elevator. We got going?
No, not with him, but to lunch.
Okay, yeah, go to lunch. You're dismissed. Get out of here. Get out. Hey, when is it, what do we have next? What time do you say? Hi. You have, lunch meeting? I was gonna see a friend in the hospital. But that's all right. I'll leave this door open. God, no, that sucker's still on. Why is it not shut off? pen. God dog, you took my freaking pen. Oh, fudge. You don't see a pen laying around anywhere, do you? With the- Like, all right.
Someone stole it.
Yeah.
I bet you was playing this house, they tried to take Katie's thing yesterday.
Yeah. That was a good pen. Well, wasn't my favorite, but it was a nice pen. It was one of those that you could actually, it had a rubber end where you can play on your phone with, the stylus.
No, you're. Oh, that's it. I'm sure space. They're always locked there. We don't take the truck. Oh, no, I think that's it. I'll see.
Mr. Hoffman,
No, he quit.
why did he, what we thought that he's on the line for the ankle.
Yeah, that is correct, but he should be back any time.
All right, I was gonna stop by and say, hey, I am a former Hoffman.
You know, it would not surprise me whenever I found out there's a judge that's actually a former intern.
That's right.
You know, it really doesn't surprise me he wouldn't have come through that door no more.
I know, there's like 300 of us these days, I think.
There's over 400 now. I got a little group.
Yeah, it's
We're
great.
taking over the Dallas.
How many interns does he have right now?
So we have 12 current law students, 2 incoming, and 1 high school.
That's great.
Yeah, and he has a second for the summer, we're gonna bring in another, I think, 6.
Keeps on going. I was at his intern reunion party the other night, and there were a lot of people there.
He has a intern reunion.
You didn't know about that,
It
Gary?
was a
did
big
not know
party.
that.
Did he not invite you?
No,
Get on
he
him.
don't like me.
He said he can't attach to Balaam
Yeah.
because he's at the meeting, so he refused to.
I believe that.
Yeah, so last Thursday, we had a reunion, at an attorney's mansion. He said he only does it anytime he does an election uncontested. So.
Right, because you had one up here to be. Have you once seen Judge Wysocki today? Do you want to see Judge Wysocki in the last month? Yes? I heard that she had COVID and then COVID started her family.
Exactly, right before she got voted, Mike, she was supposed to do hearing with her.
I've been waiting on a ruling from her, and I have a hearing with her right now, but I wasn't gonna pressure her to get a ruling on it. Anyway, good luck to you guys. I was
What's your
on
name? We can tell them yourself.
My name is Max Moran.
Okay.
Thanks.
And he should be stepping in any second now. You wanna hang out for a few minutes?
Yeah, I mean, I can do that. I don't have to. Be
Yeah, I'm telling you, he's got a deal at 1:15, so he should be coming through those doors anytime now.
Okay, well, I'll wait for him. I couldn't really guys on the law.
You can help them get ready for Jeopardy.
I'm trying Jeopardy.
It was
but
all the answers.
I think I got second, so my team got second, so I'm not gonna fail. And not leave.
Did he give a trophy?
I think it was like a coffee cup.
Oh, that's beautiful.
Something like that. Maybe a,
Yeah.
maybe a free lunch or something.
Yes, Steve Harvey.
Yeah, this is a good one. Y'all gonna like this one. Yeah, I can't even believe this. Someone's gonna favor, yeah.
I know. Let's see. Media and the president. I feel it. knew it. Okay, so you're there for the during the time of 5:35, start going over construction.
Yeah, that was about the time that I drove through there last week and got lost. Still do.
Yep. I felt like you were in San Francisco graduating from my area. Everything on campus. I'm still trying to convince my people that we will make it. And it's here in Dallas, so I was really big on staying in Dallas. And I mean, yeah. One of the things I'm like, oh, being able to. Yeah. Oh, wow. No, it's just. It's all my shirts. Yeah, definitely. I went to the, I'm like, oh, there's a lot. A lot of the reimburse gets. They know that we're all. It happened to. Are you, no, it's not.
No, I'm with that.
Where, wait, where are you? What? Lots of skills about too. That's right. That's actually a weird like. Every single oh, yeah.
I mean, I never posted anything on it. And I just have on the floor. But I'm not gonna press that.
What kind of like we're gonna be doing this, guys.
They're all like you expect. Yeah, and then most of the time see it. Some people like it. I did it.
Did you do research on
I agree. I agree. I just want to make sure they call them right.
That's the,
yeah. Oh, okay.
And you want to know what they do. And I've done a lot of. And when people come in, work.
yeah,
That's not right now.
I don't know anything about that.
It shows that you need to face level.
Hey, Josie,
And
you can always use one of those rooms in there, we're not gonna be paying them at all.
You don't have to have like your whole town and your wife's name.
yeah.
I mean, if you want.
You are going to put forward that information. Max. Right. Okay, business card, but
Tell them you want to go to March with some intern on Friday for the last one off. I bet you'll take it.
Well,
Or they're already like,
tomorrow,
breakfast.
I'll be headed to the lake house tomorrow.
That's tomorrow? Oh my God.
Tomorrow's your last day of intern?
No, Saturday. For the EYL.
So I guess none of you guys are there, so I don't see that it's like,
There's two. There's
or if you like.
You're too busy being special.
Yes, the winners of the draft.
Yeah.
What do they even draft on?
It's still right. Yeah. I feel like pretty bird.
Rolls Royce.
No one had that dog. Oh, Luke's was cool. Yeah. I think we're the next one. That's not the same.
Have you guys seen any in-person trials?
Oh, yeah.
So you said all of them in person right now?
Except for it's Charles. Great, I remember that.
Has it all been progress?
Yeah,
That Mason had?
yes, very done.
Yeah. I bet you guys know all about that.
Thank you.
Okay, well, I'll try to catch him after my hearing if he's still around. Thank you, guys.
The way you said it, like, for what? Like, who are you?
I'm just like some brother.
I thought that was Gary.
Gary's the gamer. Gary's the gamer. He's the gamer.
Apparently the sign on the door is how to go. Gary.
No. That's, yeah, that's the numerous, how should I say, the majority of the bailiffs are usually by, but like Sorolla, they're just down to earth. Jose. Oh, Sorolla, yeah. So, yeah, he's a good guy. He really is. But yeah, the majority, I don't think there's anybody with bad attitude. Yeah, we all get along. Yeah. I think we just like it easy.
Yeah, it's like, why make it harder? I don't myself.
Yeah.
Lots of the week.
Of beer.
Judge. Makes sense to me. This is really crap. She's already pulling it over. She was ready to go, Sarah. Yeah, she's sorry. Some of them, not when we were there. We were talking about coffee and onions. Those are the giant glass of iced coffee and brings it to me. I was like, sir. I love those. We were talking about straight out of a TV show or something. I'm the same here. Yes, yeah. I just, I know. It took me a minute. And then, yeah, we'll judge. I didn't realize it not so. No. Like, so weird. It's not like that noticeable. I think in the back of my mind, I was like, no way. It's what's their work. I don't think it's good. And she actually referred. Yeah.
Yeah. So, yeah. I thought I was bad.
He said,
Outside.
The dude was looking for the two Baylor guys. Max Moran. Yeah.
Oh, no. Baylor dude.
So there be Baylor, they're at lunch. Where'd you guys go?
What, 8:30, okay. And I'm pretty sure we're back at 4. Okay. Yeah.
I
don't. Oh, where's my yellow pad? No, I need a particular yellow pad.
I don't feel anything.
Oh, did a lot of people drop out? Hey, what's up?
Nothing much. I have a quick question.
Yeah, what's going on?
Are you doing weddings?
I am, yeah, but I by appointment.
By appointment. Okay, do I just email the clerk or?
When do you want to get married?
Well, I'm getting my license now. So,
Yeah.
then
So I can do it tomorrow morning.
No, I think I have to wait some 2 hours.
So I can give you a waiver.
Oh, wow.
So, but I do it tomorrow morning and then I'm gone for 2 weeks.
All right, so tomorrow morning.
Tomorrow morning, you want to come in at 9?
I might be able to, yeah. And then bring witnesses. Now, do we need a translator? She wants to expense.
No. And we have witnesses, you bring witnesses, but you don't need, it just needs to be you and your spouse. Only you need is you and your spouse. And, you know,
I'll go grab the license, have it ready, and tomorrow night.
Tomorrow's.
All right.
What's your name?
Rolando.
Rolando.
Yeah, I've done several cases.
Yeah,
here.
good to see
By
you.
the way, I just tried, I put one last month in
Uh-huh.
in Conservative County. We ended up getting that from them.
Oh, my gosh.
And I just finished one against Walmart in federal court down in El Paso.
Uh-huh.
And I have $1.3 million up. I've come up a little bit.
That's awesome. That's
So-
awesome.
So it's
Congratulations.
been a ride, so.
If you're not coming up, can you let Rhonda know?
Absolutely, that's what I mean.
All right, see ya.
Thank you.
Okay.
Can you tell if you're logged in?
So we're ending our time.
Yes. I don't see you on
Okay,
the
we have a wedding tomorrow. Okay. We had that all on YouTube. We probably didn't need to have that all on YouTube, but okay. So where's Mr. Hawkins? He was here.
Mr. Hawkins,
I
are you
think he's
logged
a
in?
breakout. Well, I don't know where he is.
Are you still in the
Rhonda,
breakout?
where's Mr. Hawkins? He was here just a second ago.
He's on the line. I'm not quite sure if he logged out.
Oh, mine. Is my sound working?
Myself.
He asked me to hold on.
Showing. Anyone else on here?
Okay, on your screen, do you see at the very bottom, it says leave? Is it in blue?
Well, is he in the breakout room? Because I've closed all the breakout rooms. So he's not here. He's not in the breakout room.
Go ahead, wherever you at, just log out and then log back in so the judge can accept you back in because we don't see you where we are.
It doesn't look like he's here on the Zoom.
Okay, yes, just hit the Zoom link again and log back in and the judge will let you in. Still there? Mr. Hawkins,
Yes, ma'am.
are you trying to log in?
Do you see me?
No, I don't see you just yet. Usually you'll pop up on the screen and then the judge will let you in. Does it say waiting for the host or something?
Here it is. I got it.
Okay, he said he sees you, so he's gonna let you in. Just a moment.
Okay.
Okay, we see you on there.
Why is it on?
Now, can you hear me? Can they hear me now?
I don't think they can hear you.
I can hear him.
I can hear.
You can hear him? Okay, they said they can hear you.
Okay, Tony, you ready to go back on the record?
Yes, Judge.
All right, let's go back on the record. What exhibits, did you guys agree on any exhibits?
We did on 3, Your Honor.
All right, what exhibit numbers are pre-admitted?
Exhibits 5, 6, and 7, 3 photographs.
Okay. Plaintiffs' exhibits 5, 6, and 7 are admitted. Did defendants have any exhibits?
I'm sorry.
Do you have any exhibits?
Yes, I had found exhibit E into the motion to the court, but it won't give me access to them for some reason. And I sent you an email to that effect.
Okay, can you email it to me and I'll email it to the judge? And the
I don't have them on my email, and in order for me to do that, I'll have to go all the way out, but there are exhibit E that was filed into the court.
So you e-filed them previously?
Yes, ma'am.
I'll look at it.
Okay.
Okay, let's go ahead and go forward with your examination.
All right, Your Honor, the last question I had was if we had a survey prepared and he testified that Garcia Company prepared a survey, and then I was going to use Exhibit 1 as my affidavit for business records as a survey. I asked the court to admit that pursuant to the Texas Rules of Evidence. Exhibit affidavit for business records of Garcia Land Data Inc., Exhibit 1.
All right, any objection to Exhibit 1?
Object to just the other exhibit. Landmark data is not a registered surveyor, and it's a record of doing the survey, and you can't perform a survey if you're not registered as a surveyor. And so I question not should be a surveyor.
Is he a registered surveyor?
Yes, Your Honor.
Let me look at it real quick. This is Exhibit 1, correct?
That's the third page of Exhibit 1, Garcia Land Data Inc.
Corporation and the survey is not a part of the corporation.
All right, the objections overruled. Exhibit 1 is admitted. All right, let's go ahead and proceed.
Okay, Mr. Freeman, I'll show you what's been marked as Exhibit 1, third page. Is this the survey that was prepared by Garcia Land Data Inc.? Yes. And do you see your building in that survey? Yes. Does it have the words metal building in the middle? Yes. And to the right is the property owned by Mr. Hawkins. Is that correct? Yes. And do you see where the boundary line is shown on the right-hand side of your property? Yes. You see that? And it would be a fair statement to say that your building is 4.5 feet on the inside of that line? Yes. Also, toward the back where it says 2 cleanouts, these are 2 cleanout valves for your sewer. Is that correct? Yes. Are both of those shown to be on your property? Yes. Okay. Also, it shows part of Mr. Hawkins' building. It says masonry building. Do you see that? Yes. Is that property building, is it on your property by approximately 6 inches? Yes. And are you asking this court to declare that this is the correct and true boundary between you and Mr. Hawkins?
Yes, I am.
And also, I'll show you what's been marked Exhibit 1A, which is, again, just a copy of your survey, but you have written in where there is also a storage container. We've listed as C, storage container. Is that actually over on your property?
Yes,
You asked the court to order him to remove that off of your property?
yes.
Can you show me on this, on where you're talking about the storage container is? Where is that exactly?
On Exhibit 1A, Your Honor, you'll have a different exhibit.
Okay, we haven't admitted 1A yet, so.
Oh, I'm sorry.
Is there any objection to 1A?
I haven't seen one.
So Exhibit 1A is admitted. Let me go ahead and share screen that. Is this the exhibit you're talking about?
I haven't seen it yet come up, but
Oh, sorry, let me do this. So where are you talking about this container?
yes, sir, it has a C on it.
The Red Sea.
Is that
Red
this right
Sea.
here?
Yes, sir.
Okay,
Okay, so are you asking the court to order Mr. Hawkins to move that storage container off your property?
Yes.
Okay. And back here in the back of Exhibit A, you see directly behind where it says behind your building on the right-hand side, there's a fence that goes from your building to the back of your property. You see that?
Yes.
Your Honor, for purpose of the record, it's at the very back where it says chain link fence points to it. You see that?
iron fence here, or is it different?
No, this one's side fence right on the right-hand side.
It's all on the property line.
It's
Here?
all, do you see that?
Right there?
No, sir, it's on our property line, directly behind our building, about 4 feet from the property line. No, to the right-hand side. You'll see right behind our building, the right-hand side, you'll see a notation, chain link fence.
Oh, I see it right here.
In the back,
Yes,
in the back. He lowered it.
you lowered it, so I can't see where you're pointing to now. Other direction. No, it's in the back. In the back.
Here,
That's the front. This is the front. There you go, right there.
right here.
Right below.
Yes,
Right below
no,
iron
right
fence.
here.
Yeah, he circled it.
Uh,
But it's below iron fence.
No, it's over to your left. There's a little X across the line in the back. That's 4.5 feet off our property. Yes, sir, that's it.
Yes.
Okay.
I see it.
Is that the chain link fence that has been there for many, many years?
Yes,
What was the purpose of that fence?
because I stored my inventory in that area behind the building there.
Okay. And it did in July of 2021, did Mr. Freeman hire a homeless man named Mr. Hawkins, I'm sorry, hire a homeless man to tear down that fence?
Yes,
And after it was torn down, did it leave it open?
yes,
Okay.
yes.
And do we have a picture that shows you standing on your property looking out to where the open fence is?
Yes.
It's marked Exhibit 5. You want to show Exhibit 5, Your Honor?
Exhibit 5, okay. Exhibit 5 has been pre-admitted. Give me a second. Right, is this what you're looking at?
Yes, Your Honor.
Okay.
And you're standing at the back of your building looking out toward Mr. Hawkins' property, and the chain link fence is no longer there. Is that correct?
That's correct.
Okay. Was it necessary for you to hire a company to come in and repair that fence
It just, yes,
or replace it?
yes.
And is that shown in exhibit? Exhibit, let me see. Exhibit 4, Your Honor, affidavit of Hollywood Fence, which is stated affidavit of necessity of services and reasonableness of charges. Would ask the court admit that into evidence.
Exhibit 5?
Exhibit 4, Your Honor.
Okay, let me go ahead and share that. Is that the affidavit and reasonableness of charges?
Yes, sir.
Okay. Any objection to Exhibit 4, Mr. Hawkins? Mr. Hawkins?
No, sir. No,
Okay,
Your Honor.
exhibit 4 is admitted.
And did they complete their work on that project?
Yes, sir.
And did they charge you a fee of $3,400?
Yes.
You asked the court to award you this money as reimbursement for repair to your fence?
Yes.
Also, Exhibit 8.
Did you say
Is this-
8?
8, Your Honor. Yeah, is this a summary of your testimony as to what happened between 7/14/2021 and 8/4/2021?
Yes.
And if I were to ask you about each one of these items, would this be your testimony?
Yes.
And so the first one starts out, Charlie Hawkins arrived in person, confront Bill about the property line dispute.
Yes.
Okay. Your Honor, I'd offer Exhibit 8 as a summary of his testimony.
Any objection to Exhibit 8?
What exhibit is that?
Exhibit 8.
8.
8. Any objection to Exhibit 8?
No.
Exhibit 8 is admitted.
And after the fence was torn down, did you hire me to represent you in this matter?
Yes, sir.
Did you ask me to send a demand letter to Mr. Hawkins?
Yes, sir.
And Exhibit 3, is that a true and correct copy of the letter we sent along with the survey?
Yes.
Your Honor, I'd offer in Exhibit 3 my demand letter to Mr. Hawkins.
Any objection to Exhibit 3? All right, Exhibit 3 is admitted. And this is your demand letter, okay?
Yes. And by us sending that demand letter, did that stop Mr. Hawkins from complaining to you about the boundary or complaining to you about the cleanouts?
Did not.
Did it stop him from harassing?
You haven't offered Exhibit 3 yet, are you?
Oh, okay, I'm sorry. I'll offer Exhibit 3, Your Honor. I'm sorry.
Any objection to Exhibit 3? Mr. Hawkins?
Agree.
All right, Exhibit 3 is admitted. Go ahead, Mr. Leak.
Okay. Did that stop him from harassing or yelling at your employees or customers?
Did not.
You asked the court to enter a permanent injunction to enjoin him from doing those acts?
Yes.
Also, that Mr. Hawkins cut telephone wires and filed false building code violations with the city of Dallas from and after that date in 2021.
The telephone wires were cut prior to that date,
Okay.
but the other several city agencies that he called on us.
And they would come out and tell you that you did not have any violations.
No violations.
You're asking the court to grant a permanent injunction against Mr. Hawkins from that.
Yes.
So you're asking the court to remove the encroachment of his building on your property line?
Yes.
And do you believe that Mr. Hawkins knowingly, intentionally did these acts against you?
Yes.
You believe he did it with malice against you and your wife?
Yes.
You're asking the court to award you punitive damages for what he has done?
Yes.
Was it necessary for you to retain me to represent you in this matter?
Yes.
Have you agreed to pay me a reasonable fee for my services in this case?
Yes.
Are you asking the court then to award reasonable attorney's fees to you in this case?
Yes.
Okay, Exhibit 6, Your Honor, is a picture that's been pre-admitted.
Are you looking at Exhibit 6? Is that what you said?
Yes, Your Honor.
Okay. Exhibit 6 has been pre-admitted.
Show you Exhibit 6. Are these the actual clean outs that are on your property?
Yes.
And they're shown on the survey?
Yes.
And these are for your sewer, is that correct?
Yes.
Okay. And then Exhibit 7. That's also another picture that's been pre-admitted, Your Honor.
Okay, I'll go ahead and pull it up. Okay.
Probably that tree needs to be stood up, Your Honor. I'm sorry. We probably didn't give it to you correctly, but if you can, I understand what I'll ask about it.
That's what we have. I don't know what else to tell you.
Okay. All right. Sir, I'll ask you about Exhibit 7. This has a picture of a tree. Is that within your property line?
Oh, yes.
And then right behind it to the side is that metal storage container. Is that correct?
Yes.
And that's on your property by several feet?
A couple of feet, yes.
Okay. And so you're asking the court for him to remove that storage container from off your property?
Yes.
I think, Your Honor, I've offered all exhibits except for number 2. I'm going to remove that one, or I don't need to admit that one. And then I have cumulative billing, I'll testify about that when I testify about my attorney's fees.
Mr. Hawkins, do you have any question? And Mr. Lee, I'm sorry, of the plaintiff, Mr. Freeman.
Yes, I did.
Okay, we're going to see if we can hear you. It's been a little hard to hear you, so,
Yes, I do have a question.
okay, go ahead.
Mr. Freeman, did you have that building constructed?
Please speak louder.
Mr. Freeman, did you have that building constructed?
No.
Did you hear him, Mr. Hawkins?
No, I didn't.
I don't think this is going to work. Mr. Hawkins, you don't have a better way to sign on to Zoom?
I'm not understanding when you say a better way.
I mean, do you have a computer that you could sign on with or anything like that?
No, this is it. I do not have to access the system. I'm at the access y'all. System's my, but I can you very well. I don't have a problem.
Mr. Leek, did you have a question?
Yes, Your Honor. I think my client said no to the question. We can hear Mr. Hawkins.
But he can't hear you.
No, I hear him now.
Okay, let's try again. Go ahead and ask your next question. Mr.
When
Hawkins?
you constructed the building, did you have the city verify that platting prior to building according to section 2102 of the local government code?
Objection relevance, Your Honor.
And also it's very, very choppy, Mr. Hawkins.
Yeah, okay, this is what I think we're going to need to do, unfortunately, is the problem we have is that unless you guys could get here in the next 20 minutes, I could do the trial in the morning, but I have other hearings, so you're going to kind of be in and out between the different hearings. And then after that, I leave town for 2 weeks. And so I got to finish trying this today or tomorrow. And I just can't hear Mr. Hawkins. And Miss Rieger, are you having problems hearing him as well?
Yes, sir.
So we're going to have to do this in person. So how quickly could y'all get here? Would you rather do it kind of in between hearings tomorrow morning?
Your Honor, I can get there in 45 minutes at the latest.
Mr. Hawkins, how long would it take you to get here?
I have one car. My wife has a car down the block wall, and she works downtown there. And so she would have to come pick me up.
Yeah, that's not going to work.
Tomorrow's fine.
All right, you guys be here, and you don't have any other way to access Zoom, Mr. Hawkins?
No, sir.
Well, now I hear him fine. That's weird. Okay. Well, let's keep trying. Your whatever you're doing now is working a lot better. So let's see if you can ask. Go ahead and continue your questions to Mr. Leek or Mr. Hawkins, and we'll see how we go.
I was asking, did you build the building according to code? And if so, did you follow the section rule 2012-045?
Object as to relevance, Your Honor.
Sustained. Go ahead, Mr. Hawkins.
The reason the relevance is on it, it advised that you have to have a platting on there to tell you where the land is and what's on that land. And if you did not do that, I was wondering why you was coming back today saying that you have a survey on your land.
Objection relevance.
Sustained. Mr. Hawkins, just so you know, this isn't an issue involving city code enforcement. If you had an issue with his compliance with city code, you would need to go to City of Dallas Code Enforcement. But you as a private citizen can't enforce that. That would be up to the City of Dallas to pursue. So let's.
Well, the reason I'm asking that because at the time there was on his warranted deed alludes to that, those regulations of advise him the reason why I asked him, did he confront the city prior to doing it? And did he go by the city ordinance that was put in place that was special warrant in 1975 concerning that lane?
Response?
Still irrelevant, Your Honor.
Yeah, I don't see the relevance of any of this. If there's a code compliance issue, that would be between the city of Dallas and Mr. Freeman or you and the city of Dallas, but that's not an issue in this case. So do you have anything else, Mr. Hawkins?
Well, the issue I'm asking is that it was advised that you could not construct plumbing on that lane. And he had to sign off agreeing to that. And if he normally intentionally broke that agreement, then come in court and want you to make it right for him doing something that he agreed he would not do.
Objection relevance, Your Honor.
Yeah, again, Mr. Hawkins, this is not an issue involving city code compliance or whether or not he's a violation of, I think you're talking about planning maybe. That's not the issue in this case. That may be an issue between Mr. Freeman and the city, but it's not an issue in this case. So do you have any other questions?
The issue of saying, the reason why I asked that, was he aware that the lines that he said that constructed on his property runs up under my property? And therefore he's trespassing by using those lines to run beneath my property. And if he's aware that he had to tap into those lines with consent from the city, and he did not get consent from it, that he's legally doing that.
He can answer that. I think that's okay. Mr. Friedman, you can answer that question.
That's where the trespass comes in.
Okay, he's going to answer the question. Mr. Freeman, go ahead and answer the question.
Your Honor, there's a long-standing easement, public easement going out of my property across his parking lot out to the main street there. It's been in place for probably 50 or 60 years.
Okay.
Did you sign an agreement that you would not, that you would use this, one second, Mr. Freeman. On your property, the address that's submitted for Omni Marble is that started out at what address?
2407 Al Lipscomb Way.
I'm sorry?
4407 Al Lipscomb Way. And you're going to need to get him, you're going to need to get Mr. Freeman closer to the mic or something because it's harder to hear him.
So the affidavit on the city saying that Omni Marble Incorporated is at 2615 South Good Latimer, is incorrect?
No,
Is it correct or incorrect?
no, incorrect. It's incorrect.
Incorrect. Okay.
Okay, then, so the city made a mistake when they put that on the, when you signed the agreement from that, when you put that address on there, that was an incorrect statement by you on the special warrant deed that you signed?
Quite understand your question.
I'm sorry?
I didn't understand your question.
You signed an agreement for Omni Marble, and Omni Marble's address is 2615 South Good Latimer, Dallas, Texas 75215. So is that incorrect or correct?
I don't recognize that address.
I'm sorry?
He doesn't recognize that address.
On Exhibit E, he signed it stating that that is the address on Exhibit A of that.
I'm going to pull up. Is that the exhibit that you had e-filed?
Yes, sir.
Exhibit E. I think I can pull it up. Let me see. All right. Can you see this? This is Exhibit E, I believe. Is this Exhibit E?
Exhibit A.
E, Exhibit E is an egg.
That's Exhibit E there, but on there, there's a picture of Exhibit A And it's a 6 of 6 on the bottom of it. If you go down to it slow, 13, 14 pages up with it.
Could you understand him? I couldn't understand him.
Well, that's the agreement that you signed right there, Mr. Freeman, said that you will not put plumbing on that property. Did you not swear and testimony to that? Keep
I
going.
have a copy of that. Do y'all not object to the relevance?
Keep going, keep going. One more. There's right there. See the address on there, Mr. Freeman? 626 15 South of Ladder. And that building is adjacent behind the lot that's attached to your lot. You have track B and it's attached, which you do not own track A. So the only way that you can get funding for track B is you have to go through property A, and you signed an agreement saying that you understood that and that you was aware of that.
That earlier address was where we were renting a building and that property right behind our place at the cashing company.
Well, it's agreed that you agreed that you would not do any plumbing whatsoever on that track B because it was against the city ordinance. And you signed it, you agreed to that, and that was put in place in 75. And you renewed it in 2002, even though you signed it in 1983.
Your Honor, I object to relevance. This is talking about public utilities.
Is it a fact that in 2002 you was aware that you was violating the rules and regulations? And they came and had made you file that agreement with the court so that you would hold them harmless if anything came of it.
You can answer, Mr. Freeman.
I don't know what you're talking about.
Your Honor, we don't have a copy of this document he's talking about in front of us. We can look at it real quick. If he'd go up to the original document, but while we're looking at it as a legal description, okay. Okay, go back to the front. First page.
No, not that.
Amendment to Unity Agreement, is that it?
Yes, sir.
Okay, that these people, including the Martyrs and the Renfros, why are you moving it for?
That's me. I'm moving it. Sorry.
Oh, okay, I'm sorry, Your Honor. Entered into a Unity Agreement dated October 11, 1983, dealing with two properties. Are those two properties your address, one of those your addresses?
24/7.
Yes, 24/7.
2407 is your, who's 2615?
Cashing.
Cashy, that's one where we had a rental office.
Okay, so it wasn't between you and Mr. Hawkins then?
No.
The landowners.
What does this have to do with the property that we're talking about, 2407 Al Lipscomb Way, I guess? How is this related to that property?
It's in adjacent of that property, and you advised Mr. Freeman that if he did any plumbing, that he would have to go through property A because they're adjacent and tap into the sewer line on that runs on that side. Mr. Freeman violated that rule and tapped into that line that's no longer existing, that had been abandoned by the city, and want to say that he have a right to it. He never pulled a plumbing permit because the city will not give him a plumbing permit on that tract of land based on this agreement that he signed. Based off this agreement, you cannot have utilities. You not have those things because it is declared as a warehouse. And Mr. Freeman was very aware of that and signed that agreement and renewed that agreement in 2002.
I guess I don't know how close is these two properties to 2407 Al Lipscomb Way?
they're adjacent to my property. And at the time in which they constructed their property, they did a survey that's a part of there. And it does not show what Mr. Freeman's survey is indicating. So I'm wondering how Mr. Freeman come back and say that that children has been cheating on his land when they did the survey and did the plotting on it, and it did not.
Good morning to this.
Your Honor, I just think this is totally irrelevant. Has nothing to do with our lawsuit. It has to do something with the city.
The lawsuit is about trespassing on your land. Mr. Freeman one has never ever said that he's seen me on his land or he ever seen me do anything on his land. The whole thing is about on my land that he wants to have access to. Mr. Freeman, how did Hollywood fencing instruct the fence on your property?
Yes.
I can't hear you, Mr.
They had a crew come out and build it along the property line.
Did they enter the property on my property or through your property?
My property.
Mr. Freeman, you're on the oath now. Did they park their vehicles, take their equipment and my property and instruct your fence on your property, instruct that fence?
I don't quite understand the question.
Mr. Freeman? Mr. Freeman?
There was no other way for them to get to there to replace the fence that you took down.
Unless they come on my property, right?
Yes.
Mr. Freeman, the clean outs you're talking about on there, how did they instruct those clean outs?
Clean out put in.
Did they come on my property or did they go through your property?
My property.
Mr. Freeman, so how did they instruct it and clean out with a fence being there from your side of the property and didn't go through your building nor the fence?
I knew where the property line was and I was well within my property there.
How did you put a backhoe on that piece of land, that piece of strip that we talked about less than 2 foot, and instruct them a clean out?
Objection argumentative, Your Honor.
You can answer if you understand it.
You had to go through my property.
Mr. Freeman, did you go through your property through Mr. Hawkins' property to be able to construct the clean out?
Yes, that's the only way we could get there. Where he tore the fence down, we had to put one back, and that's the only way we could get to it.
So you went through his property?
Yes.
Mr. Freeman, was you renting some land from me at that time?
Not at that time, no.
Mr. Freeman, were you renting land from me?
No, not at that time.
I'm sorry?
He said,
Not at
no,
that time.
not at that time.
So before when you was using the land, the only way you got access to it is with a fee arrangement that you could use it, right?
Yes.
And so during those times, you didn't feel like a fee arrangement was in need?
No.
Mr. Hawkins, did you have any more questions?
I'm sorry?
Do you have any more questions?
Mr. Freeman, you said that I cut down a telephone wire. I never cut down a wire. So when did you say that I removed the wire from your building?
There was a wire going over the top of your building and you cut it. It was my main telephone line.
It was attached to what?
He said that it was running over your property and you cut it, is what he said.
No, I never cut a wire. I actually removed those wires from my property, and I believe the phone company did. Mr. Freeman, did you ever have cable?
No.
Was it attached to my building?
No.
How
He said no.
did your cable coming to your property if you don't have utility line in between the property, which you cannot have because of the joint of the agreement that you made with property A, the owners of property A. Sure.
That telephone line went from the telephone pole over to my building, but it went over across the top of your building and you cut it.
No, but hold on. Your building is actually located at 2615 based on the agreement that you signed. You would track street that's behind that property. So any utilities you want has to come from 2615, which you are adjacent to the property. And you signed an agreement that you would agree to that and you would stick to that.
Objection relevance, Your Honor.
Yeah, sustained. Mr. Hawkins, you have anything else?
Mr. Freeman, you said that the fence was of a necessity on the storage. What business do you run, Mr. Freeman? Mr. Freeman,
Marble Company.
what do you do in your marble company?
I fabricate natural stone.
But your occupant says she does not do fabrication. He says that you're a warehouse. So are you in the fabrication or are you in warehouse?
Both.
Did you say both?
Yeah.
So have you ever applied for a right to do fabrication?
Objection relevance, Your Honor.
Well, it does give relevance to what you're doing outside the building. If you're operating within the scheme of and the contract of law, then the first thing you would do is abide by the rules and regulations that's set forth. And if you're doing something illegally, I just want to know, do you want the court to bag that?
Objection relevance. Multifarious.
Sustained.
Mr. Freeman, do you have a permit through plumbing to tap into that line that runs beneath the property?
It's an easement.
Sir,
It's an easement.
I can't hear you.
It's an easement.
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 Where is the easement shown on the property? On your deed or your warranty deed saying that's the easement?
It's shown on several old established City of Dallas properties. They came out, you had the sewer people come out and they showed you where it went from my property out to the street just to show you where it was, but they were staying strictly within the easement right of way.
Now, did you sign an agreement saying that if you was to instruct the city using plumbing that you would use 2615 good ladder?
Objection relevance. It's already been asked too, Your Honor.
Did you agree to that term?
I'm trying to get, so you're saying that he had an agreement that the utilities would go through 2615 Good Latimer as opposed to your building? Is that your property? Is that what you're trying to ask about?
That was the reason why he signed the agreement. That was the reason why they wanted to make sure that he didn't violate that and came back in 2002 and make sure that he filed that agreement with the city of Dallas. Mr. Freeman normally intentionally went beyond that agreement and installed those without a permit on the property. Being agreed with, Mr. Freeman knew good and well that he could not get utilities on there, so he used my address to attach it to his building to run it to his building. I requested he remove those wires, gave him ample time. I sent him a letter asking him to remove those wires and remove those illegal dugouts from the property. I have that letter there tells you more than anything that Freeman was in place in 1975. That became a part of his deed and contract for those two, that one lot, but was divided into two. And Mr. Freeman did not want to pay the taxation that the company was charging him to utilize the front office. So he said he'll develop his own. and illegally tapped into those lines. And illegally had those utilities installed.
Your Honor, he's objecting to a public easement for a sewer line. It's not relevant.
In the leaks,
Let me ask this, Mr. Hawkins. Do you have any affirmative, wait, Mr. Hawkins, I'm trying to ask you a question. Do you have any affirmative claims against, in this case, against Mr. Freeman?
I'm really understanding the meaning of the word. I'm no lawyer or anything like that, sir. I'm just trying to let the fact and just facts just proof. Just give you the facts of the case. So I really don't know a whole heap about what you're saying.
Mr. Leak, does he have any counterclaims in this case?
Not that I know of.
Okay.
Yes, sir. I did find that case for the damage in which he's caused me and to my Mr. Freeman, did you dig trenches in that property from your property to my property?
No.
Sir?
He said no.
Mr. Freeman, remember you are on the oath. Did you dig a trench on several occasions from your property to my property?
There was a washout between your property and mine, but it just normal water flow. I didn't dig anything.
Mr. Freeman. Now, Mr. Freeman, did you run water on the outside of your business in order to perform your duty, and that water drained from your property to my property through the trench in which you dug?
I didn't dig a trench. That was a normal wash from one property to the next. The rain drainage.
Your Honor, I'm object to relevance.
Okay, there's somebody whispering over there, Mr. Leak. I'm not sure who it is, but they need to stop. And so who else is in the room with you, Mr. Leak?
Just his wife.
His wife needs to leave because she's not allowed to whisper to you.
Okay, thank you, Your Honor.
All right. Just show the room so I can see she's leaving. Goodbye. Okay.
Mr. Freeman, did we have conversations in reference to those trenches?
Object this to relevance, Your Honor. There's no affirmative pleadings about us allowing water to run across this property.
In reference to trespass, if you dig a trench and have materials flow from your land to the next, your adjacent property, that's trespass.
Objection, it's not been pled, and it's not an issue in this case.
The question is to Mr. Freeman, did he have conversations with me in reference to the trenches he dug?
I don't see that you pled any affirmative claims, so that's not going to be relevant here. So I'm going to sustain the objection.
Mr. Freeman, what did you describe the trench that was in there as?
Your Honor, you've already objected to or you've already sustained my objection about the trench.
Okay, actually, I do see there's a counterclaim here. Let me see what it says.
Okay.
Your Honor?
Give me 1 second. I'm not sure I fully understand his counterclaims, but let me see this. Okay, I am, okay, let me just kind of share screen this of what he pled. So he's talking here about knowingly and intentionally encroaching by digging trenches to drain their wastewater under Mr. Hawkins' property. So I'm going to interpret that as being some kind of trespass claim. Okay. All right. So he's going to be allowed to ask about, I just didn't see it and no one else seemed to remember it. So I'm going to allow him to ask questions about the trenches. So did you have any questions about the trenches you wanted to ask? Mr. Hawkins?
When you dug those trenches, what was the purpose of them?
When you dug your trenches, what was you doing that for?
Mr. Freeman?
I didn't dig a trench. It was a natural wash from a paved, from a concrete area on my property to his property, which is a lower elevation. And there's a strip of land there, maybe 4 feet wide, that just went across and it, it caused a little trench there, but I didn't dig it. It was just a natural wash.
Did you clean it out? It just was natural. Mr. Freeman? Did you close that trench up? Did you close that trench up and redig it? I closed the trench up. Did you redig that trench?
I didn't dig the trench, but when you told me that you were going to continue tearing the metal off the side of my building, if I didn't cover it up, I went out and covered it up just to keep you happy until we could get to court.
Mr. Freeman, your exhibit 4. No, I apologize. Your exhibit number 5. Is that showing where the fence was tore down?
What exhibit are you wanting? Exhibit 5?
Number 5.
Okay, let me pull it up. Give me 1 second.
Yes. Yes, Charlie. Yes,
Tore down?
He said yes.
Now, is that fence tore down or did it come apart?
The posts of that fence were cut off at the ground and it was allowed to collapse.
But so you said that's the finished product of the fence being tore down?
He said, is that the finished product of the house being torn down? I think is what he said.
No, that was just during the process of it being torn down.
Mr. Freeman, when you say tore down, do you mean like ripped out, tore down, or you saying that's what you mean by tore down?
The posts were cut off at the ground and the fence was allowed to collapse.
So it's still standing there?
No,
So is that down or is that standing?
well, we pulled it in so we'd have some protection there. My guys worked for about a half a day to get it back to where we had something between our property and that, but that was clearly on our property. You were trespassing when you were doing that, and you were told that you were trespassing, and that fence was torn down. We had to do everything we could to secure our property.
Have you ever had the other side of that fence maintained, maintenance, clean, or shrubbery removed, or any of those things ever within your 40 years of being there, you said?
Rephrase it.
I'm sorry?
Ask that again.
Have you ever maintained that land that's on the side of it? Have you ever had it mowed, cut down, trimmed, or cleaned out? Have you ever did any maintenance whatsoever on that land?
Well, occasionally my guys go back and mow it.
No, I'm saying, you said you're talking about the fence. I'm saying, have you ever maintained that land?
Fence? No, didn't have to.
The shrubbery, the violations that the city comes in have maybe cleaning it and because of the scrubber that grows on, have you ever trimmed the shrubbery? Have you ever cut the grass? Have you ever raked the grass? Have you ever picked up the debris from that?
Yes,
I'm sorry?
my people have, yes.
Mr. Freeman, remember you're on the oath.
Your Honor, the objection argumentative.
Sustained.
Mr. Freeman, have you ever maintained the land? In what form, if so?
Yes, I mean, it was just there, it was on my property. And there were just weeds and stuff.
Make sure that it was clean, safe, and free of debris.
I didn't get that question, I'm sorry.
Ask it again, Mr. Hawkins. I couldn't understand it either.
In order to maintain the property, in order to keep it free of debris, keep it trimmed, mowed, and cared for, what method did you use or who have you used to maintain that property? And how much have you paid, which you saved within the last 40 years to maintain that property?
I'm object as to relevance. That's not an affirmative defense. It's not a cause of action. Ask you.
Sustained.
In order to say that it's your land, I would command you that you have to maintain a support and they'll give you your land. If you said it's outside of Texas, which you instructed and you never maintained it, how does he say that it's yours?
You can answer, did you maintain the disputed area of the land?
Yes, my guys would weed eat it.
Mr. Freeman, please advise you on the oath.
Again, I'm object. That's argumentative.
Sustained.
Again, Mr. Freeman.
Mr. Hawkins, I'm going to caution you, you can't keep saying that. That's argumentative. He's already knows he's under oath. So let's move on.
Your Honor, I like to keep that exhibit. He clearly explains to Mr. Freeman that any utilities or any use of that land for utilities did not go through the side adjacent property, that it had to go through the property that in front of it, that tells you that in exhibit E, example that the front office is located at 2615. This ladder here to that property. And anything they want to go through had to go through 2615, this ladder here, and not tap into the side of it illegally, and then bring this into your court and actually give him a right to do so after he signed an agreement that he would not do.
Your Honor, that's not even a question. That's a statement.
Yeah, you got to ask questions right now. You're just asking questions of Mr. Freeman. You can do closing arguments later unless you don't have any more questions.
When you signed the agreement, were you aware that you were not to install plumbing on the side of the property, that you was to go through 2615 with ladder?
I don't know what you're talking about. I know that the city of Dallas plumbing inspector came out and looked at all of that and said there are no violations.
Did you sign this agreement?
Your Honor, we're going back to something that's totally irrelevant. Something that was signed in 1975.
Did you sign the agreement with full intention to abide by it?
Just answer the question, Mr. Freeman.
I'm not sure just exactly what documents he's talking about. I signed.
Did you sign it with the terms to abide by the agreement? As for the tract of land?
I think he's talking about the agreement in Exhibit E.
I can't see the first page, Your Honor.
What page do you want to see?
First page. No, the first page of the agreement, there it is. Amendment to Unity Agreement. Did you comply with that?
Yes. We've done nothing that wasn't in compliance.
Did you mean to comply by
You said yes.
Yeah. Your Honor, can you go by to where you see the appraisal? I'm at the, survey of the lien.
What, is it in this exhibit or a different exhibit? You talk about exhibit 1?
Keep going, yes, sir. Keep going,
Postman?
keep going. Right there. No, go back one. There's a survey of the land right there, Mr. Freeman. Shows my property adjacent to yours. But it does not show the intrusion that you're saying is on there based off your survey in which you submitted to the court.
Objection, that's a statement, not a question, Your Honor.
I think what he's asking is this survey that I guess was done by the city different than the survey that was done that you had commissioned.
Tract of land showing your tract is A and B.
Well, Mr. Hawkins, let him finish the question. Yeah, let him answer the question. He's going to go ahead and answer the question, Mr. Freeman.
They're the same as far as I know.
Right. Anything else, Mr. Hawkins?
I didn't understand what he said.
He said, as far as I know.
So that was done back when you signed the agreement, and it did not show land intrusion. So which one of these your surveys have to believe that you bring in the court? The one that you saying that the building and the stuff that I have on the land, intrusion on the land, or the one that's done when you purchase the property?
Your Honor, again, that's not a question, that's a statement.
No, I'm asking which one has to believe. Is it that one of the surveys showing no intrusion, or is the one that he brought in the court by the corporation that provided a survey that by a gentleman that's not part of the corporation? And so I'm trying to find the legitimacy of which one the judge should use as to have the most validity in order to make an informed decision on the land.
That second one did not show the building at all on it.
It does show the building, that's the building in black, showing that it's adjacent, those two lots are adjacent.
Mr. Hawkins, you have anything else?
No, sir, yeah.
All right, Mr. Leak, do you have anything else for Mr. Freeman?
No, Your Honor.
All right, call your next witness, Mr. Leak.
Your Honor, I would call myself.
Please raise your right hand. Do you swear or affirm the testimony about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
You may proceed.
My name is Paul Leak. I'm an attorney licensed to practice law in the state of Texas. I am familiar with the fees charged in Dallas County, Texas for cases of this nature. About half of my practice is civil litigation. In this case, I have met with my client, sent demand letters, filed pleadings, sent out discovery, attended hearings such as temporary restraining order, temporary injunctions, appeared at mediation, and appeared today. In this case, I have attorney's fees of I asked the court to admit Exhibit 9, which is a summary of my attorney's fees and expenses, except for that anything that occurred after May 31st, though. I have 6 hours in this case since my cumulative statement. My hourly rate is $350 an hour. which is a fair and reasonable rate in Dallas County, Texas. I have also appealed cases from both a favorable or unfavorable decision. I believe a reasonable and necessary fee for an appeal to the Court of Appeals is $8,000, which is fair and reasonable in Dallas County, Texas. In the event this case is appealed to the Supreme Court, I believe a reasonable fee would be $5,000. I asked judgment for the trial, Court of Appeals and Supreme Court in this case. I asked the court admit Exhibit 9, which is my business record was made at or near the time of the event, made by me who has personal knowledge of this document.
Mr. Hawkins, do you have an objection to Exhibit 9?
Yes, I did. I think the fee, he says that is extremely high for the work in which he says that he does. And also, as for the expertise in which he says that it's doing, that's for someone that specializes in nothing but that field. So I object that fee that he charges is extremely high.
Objections overruled. Exhibit 9 is admitted.
I have no further testimony, Your Honor.
Mr. Hawkins, do you have any questions for Mr. Leak?
Mr. Leak, were you aware of a letter that was sent to the Freeman asking him to sit down and plot out a plan for the safety and well-being of the property with the dugouts being as high as they were and were not being cold?
I'm not talking about, I don't know what letter you're talking about. You're talking about my demand letter to you?
There's an email sent to Mr. Freeman, asking Mr. Freeman to have him sit down and discuss the health and safety that explore and admit that there may be an accident on the property if you clean out.
I'm not aware of such email. I get hundreds of emails every day. I do not remember that being received by me.
Did you try to mitigate this prior to taking it to court?
I did. I sent you a demand letter. That's exhibit. It's been admitted to court. We asked you to stop harassing my client. I asked you to acknowledge where the boundary line was. We asked you to repair the fence. We've asked you to basically comply with our request, and you refused, which resulted in our filing suit. You opposed the temporary restraining order. You opposed our request for a temporary injunction. You have never, at any time, even in mediation, ever attempted to settle or mitigate this matter.
After you put a temporary injunction, did Hollywood Fence come up on my property at that time and instructed the fence afterwards?
I'm not aware of your constructing a fence.
Well, you did. You put it as exhibit Hollywood Fence instructed the fence.
I wasn't aware of when Hollywood Fence went out there, but I know they went out there and repaired the fence.
They fought it, and that was after the temporary injunction. So after you put the injunction in place, you went and came onto the property. You instructed your client to come onto the property and instruct the fence.
I didn't instruct my client to do anything. He repaired. He paid somebody to repair his fence.
Were you aware that your client never got a permit for that fence?
I do not know.
Were you aware that you were asking for payment on that fence and it broke the agreement of temporary restraining order?
I couldn't understand your question.
You asked that again, Mr. Hawkins. I couldn't understand you either.
Were you aware that the receipt that you turned in for the fence violated the temporary restraining order?
I'm not aware that the Hollywood's fee for repairing the fence was a violation of the restraining order. No, sir, I was not.
Well, we was not to enter the property, not do anything on the property until we had an opportunity to just make a remedy for it. You turn in a receipt after you say you obtained a temporary restraining order. Then full knowledge that you broke the temporary restraining order.
Well, first of all, I don't think that's a question, and I think my client has the right to repair the fence, which was torn down or damaged by your agent.
So was the temporary restraining order for you to enter on the property and build, but I couldn't?
I did not enter on your property.
Mr. Freeman, did you enter on the property after the temporary restraining order?
I do not there. No, I was not there.
If you look at the dates of the fence, when was it constructed based off the exhibit?
I don't know the date. I'll find it real quick. The invoice was submitted by Hollywood Fence 10/28/2021.
When did you ascertain the temporary restraining order?
Was that a violation of the temporary restraining order? No, sir, I don't think so.
Not to come onto the property, not to trespass. Mr. Freeman testified already that they parked on my property to access my property in order to disrupt his fence. So you was aware of that.
I was aware of it after the fact, yes, sir, but I don't know how they could have fixed it without going across your property.
In your billing, did you charge a charge for responding on that?
No, I did not.
So you was aware that he was breaking it, that because you responded to it.
Was I aware that who was breaking it?
Bill for it.
The Hollywood Fence or Mr. Freeman?
You billed $350 an hour for the charge of responding back until why you instructed the fence on the property. They used Mr. Hoffman's property to perform duty on your property. He legally asked one to the court order and asked the state not to trespass.
Okay, I'm looking at my cumulative statement. I don't see where I've discussed the fence in here. So I'm gonna have to say no.
So you did the work for free?
No, I work at $350 an hour, but I didn't do any work about the fence other than prepare the affidavit of necessity of charges.
So you never responded to the request that are you aware that your client is violating the protective order? And you didn't charge your client?
I charged my client for obtaining a temporary restraining order, and I charged my client for obtaining a temporary injunction. Yes, sir.
And you was aware that after that he came onto the property because you responded.
I think we've already addressed that, sir. And I wasn't aware when it happened that Hollywood went across the property, but I became aware of it after it happened, but I didn't charge you for it.
You showed that it's evident as a violation of 3,512 for instructing the fence. So you was aware that the fence was instructed. And you knew he had to put it on his property. He put it outside the fence he already had, came over, he moved over to the property line and instructed the fence. You was aware of that. And you included that in your building.
No, sir, I did not. And I think you're making statements instead of asking questions. I object, Your Honor.
Stayed. Anything else, Mr. Hawkins?
Mr. Lee, I sent you a complaint from the city of Dallas advising Mr. Freeman to come out of the plumbing until he has ascertained a permit.
Objection, Your Honor. It's a statement instead of a question.
Yeah, you got to make, yes, you need to ask questions. They need to be about his attorney's fees. So he's not here as a witness otherwise. So do you have any other questions, Mr. Hawkins?
No, sir.
Mr. Leak, do you have any other questions of yourself?
No, Your Honor.
Call your next witness.
We rest, Your Honor.
Mr. Hawkins, call your first witness.
I would like to use the, warranty deed, and also show that testify to what circumstance got us to this point.
Do you want to call yourself as a witness?
Yes,
Mr. Hawkins, I really need to be able to see you, but you need to raise your right hand. Do you swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
so help me God.
All right, go ahead. Do you mind if he testifies in a narrative format?
No, Your Honor.
I'm sorry.
Mr. Hawkins, you may, what you're about to give is sworn testimony, so make sure that everything you say is correct.
Yes, sir. I got in contact with Mr. Freeman, went inside the building, advised him, Mr. Freeman, you have the clean out installed on my side of the property, and they're installed improperly. And I think we need to sit down and have a discussion in reference to that. Mr. Freeman became outraged and asked me to leave the building and don't come back. I sent Mr. Freeman an email asking him, I want to talk to you in reference to consistently violating my property. Ask him if he's going to use utilities to go into the easement that's in the back of my property. His easement would be on the front side of the ladder there. Mr. Freeman refused to do that. Mr. Freeman went and got a survey, made all kinds of accusations, supposed to sit down with me, trying to figure out in the event that those spill out, because we have them up so high, overflow, how would we clean the land if you don't have access to it? I was wanting him to pay me loss of use in the event that this thing happens, and also whatever it would take in the event those claims would get stopped up, what would give you his procedures in order to rectify his wrong. He refused to have those conversations with them. I advised Mr. Freeman that he had been violating the code for many years by having all his utilities attached to my building, which is an illegal thing. So why won't you go to the front of your building? There's a post right in front of your lane. Why won't you go through there? Why are you having to come across my property? Freeman got very, very irate, hired his attorney. So at that time, I started documenting when Mr. Freeman trespassed. I have a police report for his trespass, pictures where Mr. Freeman, Benjamin came onto the property. Mr. Freeman, the land that he's saying that he is, was fully aware that was my land, because he granted the land from me. But what I want to bring to the court is that the data that he brought to me, that began the asphalt and the amount of approximately $15,000 for to replace the asphalt for the gas and digging the trench, cause his water to come off his property onto mine. But the use of the land for his wiring and for his cable, his phone, and also for his bad act. If Mr. Freeman would have operated within the scope of the city building code or to the agreement that it reads, we wouldn't be here having this conversation, or we would be going to the whatsoever. When Mr. Freeman hired the attorney, I got in contact with the attorney, tried to get him to work out a deal concerning the damage. He got a temporary order that I do not contact the plaintiff nor contact him in reference to that. Therefore, negating the liberty to our problem and brought this in the court. And I ask you, Judge, Your Honor, if you will see that he admitted that he violated every time by coming onto my property, I never gone to his property. And there's no one can testify that I was on his property. He's never put up no trespassing sign to say that there's trespass. He's never sent a letter to me advising me that I was trespassed. So therefore, I don't see how he can say that I'm trespassing when he never gave me ground room.
Is that it, Mr. Hawkins? Do you have anything else?
No, Your Honor.
Mr. Leak, do you have any cross-examination, Mr. Hawkins?
No, Your Honor.
Mr. Hawkins, call your next witness.
I'm sorry.
Call your next witness.
I called Jill Freeman.
Who? Jill Freeman? Is that Mr. Freeman's wife?
No,
I think he said Bill.
Well, everyone calls you Bill, and that's what I've known. I've always called you Bill.
Okay. Didn't he just testify?
I'm sorry.
Who are you calling? Bill Freeman? Is that the guy?
Mr. Freeman, have you ever advised me that I was trespassing on your property?
Mr. Freeman, you're still under oath. Did he ever advise you you're trespassing on his property? He can't hear you. You got to get closer. You got to get closer to the mic.
Did he advise me that I was trespassing on his property?
Yes.
Yes, when the fence people were there.
Okay.
He called the police, and they came, and they said, as far as any trespassing charges go and everything, it's a civil matter, and it had to be settled in court. And they left.
Okay. Anything else?
Who called the police?
You called the police?
I think he did, yes.
You got to get closer. I cannot hear you, Mr. Freeman.
He did.
Okay, thank you.
Mr. Freeman, have you ever advised me that I was trespassing on your property?
Well, yeah, several times when you were arguing about the clean outs and
Was
anything.
I arguing you about that?
I told you sometime back that the property line kind of ran down that old curb line there, and you said there's no way. So I just let it go at that.
Was I on your property?
Yes. When your people are tearing the fence down, they were on my property.
No. Have you seen me on your property trespass?
Well, yeah, I mean, you come over to the business all the time, or did, till we got a restraining order, and you come over and harass my employees. You're yelling at the surveyors, and just basically harassment.
What, Mr. Freeman? What employee of yours would you say that I have? Wait, first of all. So you would say that I never trespassed on your property?
Objection, he said he did trespass.
Yeah, I think, Ms. Hawkins, he did say that you did trespass.
When did I trespass?
He already went over all this. He just told you when you trespassed.
Was I on your property when the police was there, or was I on my property?
That's the police, and you were on your property as were the fence guys. But when you had the guy cut my fence down and everything, we were standing right there beside him and everything, and he was definitely trespassing. He's tearing my fence down.
Have you ever advised me that I was Charlie Hoffman, that I was trespassing on your property?
Just when you came into the building and harassing my employees.
When you say harass your employees, you saying that I came into your building and I harassed someone? No, wait,
Yes.
Have you
Yes.
ever advised me that Mr. Hoffman, you was trespassing on my property? So you saying that you asked me to leave your property because of disorderly, fashion, but I'm saying trespassing. Have you ever advised me that I was trespassing on your property?
Objection asked and answered, Your Honor.
Sustained. Let's move on.
Do you have signs posted saying no trespassing on your property?
Outside the building, it says we have an alarm system.
Do you have signs saying trespass, no trespass?
No.
Hello?
He said no. He does not have signs that say no trespassing.
Have you ever sent me a letter referencing your trespass?
Mr. Freeman, you need to answer the question.
What was the question again?
He said,
Sent you a
he
letter.
sent you a letter about him trespassing.
Yes, Mr. Leak did.
Before Mr. Leak sent the letter, Mr. Leak said he came in and said that I was trespassing. Let me ask you this.
Dated August 12th, 2021.
When was the police call for you trespass?
I don't know. I don't remember.
Was it, Mr. Freeman, was it before or after the letter that Mr. Leak sent that this whole confrontation with the police happened?
After.
Anything else, Mr. Hawkins?
Mr. Freeman, did I ever advise you that you were trespassing?
You claim trespass all the time when I was working on things that were on my property. You were over there screaming at my people and the surveyors and stuff, saying we were trespassing on your property when we weren't. It wasn't your property.
If you're, I'm gonna ask, with the fence being there that you placed there, was I supposed to think that that was your property on which side of the fence?
Objectives vague and ambiguous, Your Honor. I don't know which side is he talking about.
Mr. Freeman, did I maintain the property on that side of the fence from your place that's adjacent to your property?
Well, between the buildings, no, except occasionally.
Did I maintain that property?
Yes.
Do you remember a time when the homeless had moved in there and just put feet all up beside that building and trash and things?
Yes.
Who cleaned that, Mr. Freeman?
That was last month.
Who cleaned that, Mr. Freeman?
You did last month.
Mr. Freeman, have you ever paid to have any of that stuff removed or cleaned or taken care of? And on that property?
Object as to relevance, Your Honor.
Sustained.
Tied to ownership. And if I maintain the property and then, but you said it was your property and you never maintained it, then did you make the accusation that it was my property?
Again, you're making a statement instead of asking a question, Your Honor.
Sustained.
Make me believe that it was my property, so I demanded I maintain the property.
I don't understand what you're asking. That's a little 4.5 foot wide strip going up through there. And all kind of debris from that homeless guy there spilled over on it, but we'd toss it back over onto your property.
On my side.
Yes.
But now you're saying that's your property.
I don't understand. I'm saying,
I can't hear you.
That was my property, would you say?
yes.
Mr. Freeman,
Anything else, Mr. Hawkins?
believe that that was my property, right?
I don't understand the question.
I think he's saying, if I understand him, that you were throwing, there was trash that was on your property that you threw back over to his property, but you were earlier saying that where the trash was thrown is his property,
Yes.
not your property. I guess, I'm not sure I'm following him.
Your Honor, there's a homeless guy. There's an old Volkswagen convertible sitting there that a homeless guy gets into, and he just throws stuff everywhere there. I mean, he's had as many as 3 grocery carts loaded stuff, and he just spills it all over. And when it's on our property, we just put it back over on his property because he's the one that gives those people permission to stay in that old Volkswagen there. He's never done anything to stop them.
Okay. Anything else, Mr. Hawkins?
In the last 40 years, have you ever paid for maintenance on that property?
Object this to relevance, Your Honor.
Ever paid for maintenance where?
On the property that he said that it's his property. Has he ever cleaned it? Has he ever paid for it?
Have you ever paid for maintenance? I think you've already asked this, but have you ever paid for maintenance on the disputed area of the property?
Yes, my employees do that.
Okay. Anything else, Mr. Hawkins?
Do you have employees in your warehouse?
Several employees.
The foreman. Bill, you on the oath.
I'm sorry, I didn't get that.
You said you're under oath.
But you never seen me on the property, you never gave me notice, right? Is that correct?
We've already gone through all this before, Mr. Hawkins. If you have any questions that are new questions, you can ask questions.
I have no more questions.
You don't have any more questions? Okay. Mr. Leek, do you have any more questions?
No, Your Honor, we close.
Okay. All right. Any more witnesses, Mr. Hawkins?
No.
Did you say no?
No.
Okay. All right. We're going to do closing arguments. I'm going to give each side 5 minutes. And I'm going to have Ms. Heimberger go ahead and keep time. Ms. Heimberger, if you could come behind me so that they could see you. All right. Mr. Leek, do you want to reserve any time for rebuttal?
No, Your Honor.
All right. You have 5 minutes.
Your Honor, this case began back in July of 2021. My client has a very reputable business at that location. He and his wife only want to be left alone by Mr. Hawkins, but Mr. Hawkins came over in July and said that the area of the building was over on his property, his boundary, and he had some kind of document that wasn't a survey to try to say that proved it. So my clients went out and got a survey and basically told him not to continue to trespass. But also during that time,
I get all that. Explain to me the relevance or lack of relevance of Exhibit E for the defendants.
Okay. I have no understanding of what Exhibit E means. It has to do with an agreement between my clients and another party who are not in this matter, dealing with a 1975 agreement for some type of access or utilities or something. And that's all I can understand that it is, Your Honor.
Okay, go ahead.
In any event, Your Honor, we've had to put a fence back up. We've had to obtain a temporary restraining order. We had to obtain a temporary injunction. We have sought to have this gentleman understand that the boundary is set forth in the survey is accurate.
Mr. Leak, I want to make sure I understand what you're asking for. You're asking for a permanent injunction. You're asking for a declaratory judgment. You're asking for, as I understand it, the amount, $3,400 in damages for redoing the fence, and then you're asking for $10,559.58 for attorney's fees, plus I think you said $8,200 for appeal.
Actually, in my attorney's fees affidavit is $10,560. That was through May 31st.
Okay.
I have an additional 6 hours. That's $2,150. I think it is about $12,710.
Okay.
Also, and for $8,000 for the Court of Appeals appeal and $5,000 for the Supreme Court appeal. We're asking for the actual damage, what it costs to repair the fence. We're asking for punitive damages. We believe that the actions of this so-called neighbor have been malicious, and anybody in Dallas County would not want to be living next to this gentleman the way he's treated my client. So unless this court sends a message to him, I don't think he'll ever get what it means to be a good neighbor. And we ask the court to grant us judgment for the permanent injunction to not harass our clients or employees.
Which cause of action do you have that? So your causes of action are for permanent injunction and for declaratory judgment.
Right.
I don't think either of those allow punitive damages unless you also asserting, I guess, trespass.
Asserting trespass.
Okay.
Yes, sir. And but we asked for injunction to enjoin them from harassing our clients and employees and my clients. We asked to order him to remove his storage container off the property line. We also have shown that his building encroaches by 6 inches. We ask that be removed also. And we ask the court for all our costs of court. Thank you.
How much are you asking for in punitive damages?
Your Honor, I think 10 times the actual, so
30
about
seconds.
$45,000. I think.
I thought it was 3,400.
I'm sorry, Your Honor, you're right. So $35,000, I think, is fair and reasonable in this case.
Okay. All right, Mr. Hawkins, you have 5 minutes.
Dear Governor, this case started about the cleanout. And for cleanout that was causing a nuisance to the property, I asked Mr. Freeman if he would be so kind to bring them down the code and sit down and have a business. He used to do that. He brought a survey, which if he wanted to use, he should have used those during the time prior to constructing the building, and then they should have been done. If he's trying to say trespassing of that over a 40-year period of time, which was not. He never advised me trespassing of it, gave an opportunity to limit it, and therefore should not be granted the right to receive trespass. Due to the fact that he just didn't act by coming onto the property, obstructing the fence, coming onto the property.
4 minutes.
Illegal clean out, also by instructing utilities to instruct and put his utilities onto my building in order to serve his property, showed well, and by taking interest in my property, that he was trespassing just relentlessly. And if I did say nothing to him, it would just continue to go on. I think that Mr. Freeman, his attorney, has years and years of history with each other, where they went back and have always done this type of things to people, that you show them that their bad acts are not appropriate. And if Mr. Freeman wanted those things, he should have went by building codes and agreement that he signed with the landowner, at which he just has a portion of tract of land. And that he did not go by those rules and regulations that he said that he would verify, and caused me all this headache and call. And I asked that he reward me in that,
3 minutes.
the damages and the amount that's indicated on the previous, quote that was submitted in the report.
Do you have anything else, Mr. Hawkins?
No, Your Honor.
Okay, Mr. Hawkins, this is a kind of an unfortunate situation. I think the problem you have here is partly that you had an attorney and now you don't have an attorney, and I think you've done some stuff you shouldn't have done. I'm not sure what I can do to kind of get you to stop doing the things you're doing. You have to understand, if you have an issue with the city or a HIBS violation of doing some kind of, something in violation of code enforcement or some kind of city ordinance, it's not your role to take on the role of a vigilante and try to correct that. You have to go to the city. And so I think that's what some of this problem has happened, is that you're kind of taking self-help remedies. And so I would highly urge you to before you do that again, to contact an attorney. I'm going to go ahead and rule in favor of the plaintiff. I'm going to rule that I'm going to extend the temporary injunction into a permanent injunction. I'm going to award damages in the amount of the repair. I think it was $3,400, but whatever the exact number from the repair on Exhibit 4. I'm going to award attorney's fees in the amount of $12,710 plus $8,600 in appeal, plus $500 for appeal to the Supreme Court. I really wrestled with this idea of punitive damages. Mr. Hawkins, I don't want to have to award attorneys punitive damages against you, but this is the one trial that I have. And so do you feel like you understand what the problem is here? And are you going to keep doing what you're doing? Or are you going to try to be a better neighbor?
No, I haven't done anything.
Okay.
I haven't went on his property. I requested the utility companies remove those wires, because I have never done any of them. I've never cut a wire. I've never done any of those things. The utility companies removed that from my building, but I've never, ever did any trespass on them. I advised them that he needs to have it, and I was going to ask them to remove it, but I've never removed anything from his property. Never been on his property illegally.
Mr. Hawkins, I don't know. I really am struggling here because I don't feel like you're getting the message here, and maybe I need to be stronger about it, which is there's going to be a permanent injunction in place. If you violate the permanent injunction, there's two remedies. One is a $500 fine per violation, and then up to 6 months in jail. I don't want to have to do that in the future. You need to stop doing what you're doing. Get an attorney if you feel like there's something that Mr. Freeman's doing that he's not supposed to be doing. Get an attorney and say, hey, look, he's not supposed to be doing this. I need to get some kind of court action. I don't feel like you're getting the message here, which is you can't do self-help. You can't hire homeless people to tear down fences. You can't just violate the law. And so I don't want to award attorney's fee. I don't want to award punitive damages here, but I don't know that you're getting the message of what's going on here. You've lost at every single level of this case. Your attorney withdrew from the case. I don't want to have to punish you any more than you're going to be punished. But I feel like you're not getting the message here. And so are you going to tell me that you're just not getting the message and you feel like you've done absolutely nothing wrong and that you're going to keep doing what you're doing?
Your Honor, you said that I brought some bad acts here where I did some things. Your Honor, the only thing I did ever was try to talk to Bill about what we're gonna do about this. But now, as far as me doing anything wrong, I never hired no one to do anything wrong. I never spent no one on this property. I never did anything with that stuff. And I haven't been on that property since, I haven't been on that property in 12 years. I've had cancer and I haven't been on that property, but I came back from having cancer. I had why he struck Bill clean out, and that's it. I have never done anything to that, to Mr. Clean or anything like that. But he said that I did bad act. I never paid no one to cut down a fence or anything like that. I tried to get rid of the city. If he says that he cut down that fence, let's deal with it. But I've never done anything like that.
All right, Mr. Leak, I'm going to give you each an additional 1 minute to argue about the amount. Mr. Hawkins, I'm really trying to help you here. I wish you could sense that, but you're obviously not. I don't know what else to say. So we're going to have to consider punitive damages in this case. So Mr. Leak, why don't you?
Not give the punitive damage. In fact, that I have not had an opportunity to remedy this case whatsoever. When I came on, it was a lawsuit against me.
Mr. Hawkins, we've sent you to mediation to try to get this case settled. You guys didn't settle the case. I've had meetings with you as well. I'm
Said that we was foreign places. Asked, how much money did you want? She said that Mr. Freeman wanted X amount of money. You want she was all too far from between each other. I'm not going any further. And as far as the mediation went.
Mr. Leak, why don't you make your arguments on punitive damage, and Mr. Hawkins, you'll have an opportunity to respond.
The punitive damages, sir.
No, Mr. Hawkins, it's not your turn. It's Mr. Leak's turn.
Your Honor, I think in this case, this is the right case to award punitive damages. I'm not asking for 100 times punitive. I'm just asking for 10 times punitive damages, $35,000, which is fair and reasonable because this has been a nightmare for my clients in dealing with a neighbor. No one should ever have to have a neighbor like this. And I think if you do that in this case, it'll send a message to not only him, but anybody else that's thinking about harassing their next door neighbor. And I asked the court, I think 35,000 is very fair.
Mr. Hawkins, understand that this is about whether you should be punished or whether or not you've learned anything from any of this. I'm going to give you one last shot here. You have 1 minute to make arguments on why you shouldn't be awarded punitive damages.
Your Honor, as far as Ms. Spring's a good neighbor of mine. I've always got along with him. I don't have no problems with staying away from that property, not being on that property or near that property. Money. I don't go near that property. I don't work anymore. I can't afford to work anymore.
30
because
seconds.
of my cancer, and I can't afford anything you put on me. And so I'm not really sure what this is all about. Like I said, I haven't been on the property in 10 years, 15 years. And I will not be going on to the property. I will not call any debt. And Ms. Spring don't have a problem with me. I asked that you not give me the damage. But all I want to do is to figure out what was safe and best for the community, not for any
Time.
coaches or anything of that nature. And I wasn't trying to be a preacher in no form or fashion.
All right, give me a second, and I'm going to make a decision on punitive damages. I'm going to put you guys into a breakout room to see if you can't work out some kind of agreement.
Some kind of agreement for what, Your Honor?
Just a settlement of the whole case. I don't know that that's helpful, but I'm going to put you guys into a breakout room.
Okay. All right. Thank you.
So Bill, you said I only
Wait, just a second.
So Bill, this,
You need to go to the breakout room.
hello,
It's gone. Okay.
hello.
Oh, is he, Rhonda, is he still, you need to, I guess you need to go to the breakout room too to talk.
Okay.
Poor Rhonda.
So Bill, this is about money.
Hold on, sir, hold on.
All right, this is an interesting case. I very rarely award punitive damages. What do y'all think? What?
Judge.
Oh, my-